Cross-examination, Mr. Ho.
Sir, you indicated that you neither trust nor like the police. Is that correct?
I said that.
I'm going to suggest to you that you especially don't like or trust Officer Fantasia.
No, I don't.
Especially now that as a result of this incident, you had had your parole revoked and gone back inside for another 6 months. Isn't that correct?
As a result of this incident, that's correct.
Now, I know that we've filed the record. I'm going to talk about the record a little bit. Your Honor, if I could see exhibit number 2, please.
Here it is.
Sir, you were convicted of theft under on January the 23rd of 1998. You received an absolute discharge, correct?
I guess that's, if it's on the record, it must be correct.
And on February the 3rd of 1999, you also were convicted of fraud under. You received a suspended sentence for 12 months with probation, correct?
Can you repeat the date, please?
February 3rd, 1999.
Yeah, I have an extensive criminal record, so...
Right, well, we're going to talk about that as we go through it. And then on December the 10th of 1999, you were convicted of uttering a forged document, breaching probation. You received a total of 9 months in jail with another 12 months probation, correct?
If that sounds like my MO, that's correct.
And then on October the 10th of 2000, you were convicted again. I'm going to suggest to you of a fraudulent type offense, double doctoring, 5 counts, giving a false name, and you received a total of 15 months jail with 3 years probation, correct?
I have a very extensive record. It's probably correct, yes.
Right, and January the 5th of 2002, forgery, breach probation, you got another 18 months, plus another 3 months, correct?
Sure.
February 14th of 2004, you were convicted of theft over 2 counts and fraud under. You received a total of 10 months in jail for that, correct?
Yep.
And then the last conviction that we have on the record is from March the 15th of 2006. You were convicted of possession of a narcotic for the purpose of trafficking, and you got hit with 6 years on that one, correct?
That's why I ended up being in the federal institution in parole. That's correct.
Right, 6 years is a long time.
Sure is.
Inside, isn't it, sir?
Sure is.
And I'm going to suggest to you that it was Officer Fantasia who was the officer ultimately responsible for investigating and arresting you on the charges that ultimately put you in the federal penitentiary for 6 years, correct?
Yeah, he's a real peach.
And it's your view, is it not, sir, that conviction for that offense was something that you, in fact, didn't do?
That's what I maintain. I didn't do it.
All right. And was that conviction, was that after a trial or was that a guilty plea?
That was not during a guilty plea. This was a trial.
All right. So a trial took place, a judge and jury heard evidence and convicted you of that offense, correct?
That's correct.
And is it your view, sir, that Officer
Mr.
Fantasia...
Marley, you have an objection here?
Your Honor, yes, I do, to this extent, and I'm sorry, sir, I was...
Mr. Houle, Section 12 of the
That's right.
Canada
It can only
Evidence
go
Act
as far as the...
allows you to ask him, hold on, maybe I'm wrong.
No, the particulars of the conviction are fair game. The
But
facts
he's
that go
not the
behind it are
accused.
not.
He's not the accused.
No, he's not the accused.
He's not the accused, and I may have to apologize to Mr. Houle, because if he was the accused, Mr. Houle could only ask him about the conviction and the sentence, but I'm not sure that applies if he's a witness. I assume that's your point, Mr.
Well, it is, and it would mirror the ruling that you gave earlier, sir, I
Yeah.
think, as it relates
I
to
think,
the...
I think, Mr. Marley, that I'm incorrect, and I owe Mr. Houle an apology because this gentleman is not the accused. He's a witness in this situation. So, Mr. Houle, I will allow you to go on, and I will apologize to you for interrupting you.
Thank you, sir. So there was a trial that took place, a judge and/or judge and jury heard the evidence and ultimately convicted you, isn't that right?
Yes, sir.
And is it your view that somehow Officer Fantasia did something that was dishonest or unprofessional that resulted in you receiving that conviction?
Dishonest and unprofessional, to say the least, yes.
And tell me about that. What is it that you think Officer Fantasia did to you that resulted in you going to jail for 6 years?
Well, he lied to the court about what I was doing. Shall I elaborate?
Well, it's up to you, sir. I've asked you the question, so go ahead and tell me. How do you think Officer Fantasia lied?
Well, he told the court about a certain offense in question that I knew that a parcel that I was accused of delivering contained heroin inside, that I knew how much it was, and that I told him that I knew that it was heroin inside and how much it was. He even fabricated a location as to where I was supposedly dropping it off, and he lied to the court, resulting in my conviction.
But you'd agree with me, sir, that you're the one that has a record for dishonesty, correct?
A record for dishonesty?
Yes.
I maintained that I have an extensive criminal record for nonviolent crimes.
Well, sir, we've gone through your record, and would you not agree with me that the majority of convictions on your record are crimes of dishonesty, fraud, theft, double doctoring, giving a false name? Those are crimes of dishonesty. Wouldn't you agree with me?
Yes, those are certain. Yes, I would agree with you.
Right. So, in fact, you're the one that's the proven dishonest person. Isn't that correct?
I said that I was convicted and that I had a record. I never admitted to doing anything on the stand here today.
And so all of those offenses then that you were convicted of, you don't admit to? Those were all wrongful convictions for you?
I prefer not to admit guilt here today.
Well, unless His Honor directs you not to answer the question, you need to answer my question. Are you saying that each one of those convictions on your record were somehow wrongful convictions? You are innocent of those charges?
I'm going to direct you to answer that question, sir.
I'm not going to say that I have never committed crimes. I will say that some of those crimes for which I have a record for, I was indeed guilty of.
And some you were not?
Yes.
All right. Which ones were you not guilty of? Would you like to have the record in front of you, sir?
Sure.
Exhibit number 2. May I approach the witness, please?
Yes, of course.
Sir, you go down this list for me, please, and you tell me which ones of those convictions you are not guilty of.
I'll admit to theft under, fraud, under forged document. I'd say I was not guilty of breach of probation.
I'm sorry, the first ones you admitted your guilt, the breach of probation, you say no.
That's right. Most of these, particularly the drug crimes and the property crimes, I'm indeed guilty of.
It'd be fair to suggest to you, sir, by your own admission, that you're not necessarily a very honest guy.
I'll admit to you that I have committed certain crimes to feed a drug habit.
And on this particular occasion, when you saw Mr. O'Brien strike Officer Fantasia, you in fact told police officers that you hoped that Officer Fantasia's jaw was in fact broken, correct?
I did hope that Officer Fantasia's jaw was broken.
Because you wish him harm?
I wish not to direct him harm from myself, but I would like to see harm befall him, yes.
Right. And that's why you're here today, not being truthful with this court about what you saw and about what happened on the night in question. Because you want to get back at Officer Fantasia, and this is your way to do it. Isn't that right?
I said that I would be truthful, but there's no secret here that Officer Fantasia has lied on the stand to me, and I do not like him.
But you and the truth, sir, aren't exactly best friends, are you?
No, we are not.
Right.
So we just had a question about the difference between a criminal record for an accused who's testifying and just a witness who's testifying, and to what extent can the criminal record be brought up by the Crown in cross-examination?
Well, as His Honor indicated during the course of the trial, when it's an accused testifies, they have, in some ways, special treatment. And as it relates to a criminal record, the Crown is entitled to ask or put to the witness the date of the conviction, what the conviction was for, and what the sentence. The Crown generally can't go beyond that for the purposes of cross-examination. In this particular case, there was a person who was not the accused, but a defense witness who had a lengthy criminal record. And in this particular case, the Crown not only cross-examined on the convictions and the dates and the sentence, but also attempted to go behind those convictions to get some of the details about whether it was a trial or a plea and whether the person felt he was really guilty and all of that kind of stuff. And as His Honor indicated, a witness is treated differently than an accused as it relates to that, and the Crown was able to do that.
And also, just as a follow-up, you mentioned that where there is, where the Crown is cross-examining an accused person about their background, their criminal record, typically they'll only bring up the kinds of convictions that go to their dishonesty. Can you elaborate on that?
Yeah, that's generally the practice. The Crown has to be very careful that we don't get into a past discreditable conduct type situation. So we will generally cross-examine on crimes of dishonesty like theft, fraud, break and enter, those types of things, in order to go to the person's credibility or to attack the person's credibility.
With your second witness, you asked the judge if there's no issue with respect to identity, and then you went on with your question. Could you explain why you asked that question?
Well,
What happens if a Crown fails to satisfy the issue of identity?
Well, identity is obviously one of the primary components to the Crown obtaining a conviction. We have to prove it's this person that committed the offense. And generally what we'll do is we have identity satisfied by a witness pointing out that person. In this case, the first witness did that. If there was still some issue with regard to identity where the defense was going to attack that issue, then I just wanted to make sure that I didn't have to do it again with the second witness, and we move on from there. And that's what we did.
Can you tell us what a voir dire is, and what are some best practices as it relates to a voir dire?
Go ahead, Your Honor.
A voir dire is it's called. I know a little bit of French. I guess it's the literal translation is to see what's going to be said.
A look-see.
Yeah, a look-see. And for instance, Craig made a couple of objections, and you might say, for instance, the first objection was Ken's first question. You had a conviction under the Police Act for, his term was misappropriating the funds. Craig's was not misappropriating. Well, if there was a jury there, we would say, okay, throw the jury out. The jury goes back, has some coffee. I ask Ken, I say, you tell me what this evidence is. We might even keep the witness there. Have Ken ask the questions, have Craig respond, cross-examine or re-examine rather, and then they would submit, this is relevant. Ken would say it's relevant. Craig would say it's not relevant. I would make a decision. If I say it's relevant, we call the jury back, the evidence is repeated. If I say it's not relevant, the jury never hears about it. The same thing happens with a confession. The Crown will say we're at a point, Your Honor, where we have an evidentiary item to consider. Ken will say, yes, my client confessed, but the police beat it out of him. Craig will say, no, they didn't beat him up. So you go through, you hear all the evidence, as to whether what the police did, how they did it. Now it's a little easier because, except for the Toronto Robbery Squad, most statements by an accused are supposed to be tape recorded, which doesn't end it because good defense counsel will say, well, what happened before you got into the interview room, which wasn't on tape. If I decide that the statement was made voluntarily, it gets admitted after I make a ruling on the voir dire. Yes, it was made voluntarily, or no, it wasn't. Or, no, the Crown has not proved it was made voluntarily. On a charter breach, the onus is on the accused. So I would say the accused has achieved its onus, and therefore, and its onus under the actual section of the charter plus section 24(2). If the accused achieves the onus, the jury doesn't hear it. If the accused doesn't achieve the onus after the voir dire and the judge's ruling, the jury hears it.
In terms of best practices, you'll know, if you know your case well, you'll know what issues are going to be controversial and which ones aren't. So you have an opportunity to prepare for that. The best practices is when you are examining a witness and you get to that point where there's going to be that controversy, you should alert the court to it before you even get there. Your Honor, I anticipate the Crown's going to object to my next line of questioning. Can we please embark on a voir dire? Will you excuse the jury, please, and can we embark on a voir dire? So in other words, don't try to sneak it in first in the hopes that the jury is going to hear it, but meet it head on. This is going to be controversial evidence. So, Your Honor, we're going to deal with it in advance. Sometimes when you prepare for a trial, you actually agree with counsel for the Crown in advance, we're going to have a voir dire first. And then, so you might say, Judge Rogan, please tell the jury to come back on Wednesday. We're going to need Monday and Tuesday to have our voir dire first. And so if the more you can do that, the better you are able to prepare for the voir dire, and the better you're able to make sure that the trier of fact isn't tainted by hearing something that they shouldn't hear. So in terms of best practices, that's what I would say. Either arrange to do the voir dire in advance of the start of the trial, or at least alert the trier of fact to the fact that you need to have a voir dire before you get to that point, before you actually start into the controversial evidence. And the only other thing to do is make sure you know the law of evidence so you're ready to argue as to the admissibility or not of the evidence. Crown counsel are very well trained generally in doing that. They will tell you, Your Honor, I'm about to elicit what I believe to be an inculpatory statement from the accused. Can we please embark on a voir dire? And again, if you are defense counsel and you know your case, you'll already be ready for it. You'll know what witnesses you're going to call, what submissions you're going to make.
Do all of those points apply when it's not a jury trial?
Yes. Now, the thing about a non-jury trial is that, and it's probably the worst thing about a non-jury trial, is that your trier of fact hears all the controversial evidence.
Here's the evidence anyway.
Right. And we all trust that judges disabuse their minds of the things they've heard in the voir dire and only accept as facts, or as evidence rather, those things that are determined to be admissible. And we have to do that. That's the only way you can fairly assume that a judge-alone trial is fair. And in my experience, that's always been the case. I've never had that concern that a judge's ultimate decision was based on something that they heard in a voir dire that was determined to be inadmissible.